Butler County, Kansas, case entitled State of Kansas versus Jordan J.D. Dillon, case number 2023 CR 82. James Watts appears as defense counsel, Amber Norris on behalf of the state of Kansas. Jordan Dillon appears from a court security Zoom location at the Butler County Judicial Center. Before the court is a warrant to show cause alleging probation violation, including failing to obtain full-time employment as directed, positive urine samples, failed to re-engage in substance abuse treatment as directed by his ISO. Mr. Watts, what are your client's intentions regarding these allegations?
Thank you, Your Honor. As to the first allegation that failed to obtain full-time employment, my client would acknowledge at the time of his arrest on this warrant to show cause, or at least at the time of the issuance of the warrant to show cause, he did not have full-time employment. I will note for the record, my client tells me he is now working at Spangles, in fact, has work tomorrow. So that has changed. As to the second allegation, submitted positive urine samples on a number of dates, he would agree with that and stipulate to that violation. And as to number three, failed to re-engage in substance abuse treatment, he would acknowledge that at the time of the issuance of the warrant, that was correct. He would stipulate to that violation, would tell the court he is now, and it's my understanding Mr. Ketley is aware of as well, is now back in a treatment program.
All right. All right, Mr. Dillon, you do have a right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence, present your own evidence, confront the state's witnesses unless good cause was shown, and among other lesser remedies, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, Your Honor.
Do you waive a hearing and stipulate and agree that you committed the violations as qualified by your attorney, no doubt, as to 1, 2, and 3 of the warrant to show cause?
Yes, Your Honor.
All right. Court finds that the defendant has waived a formal hearing on the allegations, stipulates and agrees that he committed the violations as alleged. Mr. Ketley, can you confirm that the defendant has re-engaged in a substance abuse treatment program at this point?
Yes, Your Honor. On 3/11, he met with Higher Ground and they went back over his evaluation and reinstated him into treatment.
Very well. Has he provided any verification of being employed?
No, but when I met with him when he was taken into custody, he mentioned he was working at Sonic, and I even spoke with his grandma, and his grandma had admitted it or had stated that he was working at Spangles also in Andover.
Okay. All right. Do you have recommendations at this time, Mr. Ketley?
Well, Your Honor, we've had, I was kind of hoping it wouldn't have got to this point. We've already had 2 sanctions for roughly the same type of stuff, using marijuana. And Cedar County said that until we have a little bit harsher sanction, then they sent him back, but they will take him back if it gets to that point.
All right. What are the state's recommendations here, Ms. Norris?
Our state be recommending 30 days in the county jail. This is defendant's second warrant to show cause. And in the interim since the previous show cause, which was in June, the defendant has had both a 2-day dip and a 3-day dip that he agreed to voluntarily with his ISO, both of which had to do with him not getting back into treatment. So that has been a consistent problem since the last warrant to show cause. So we would ask 30 days in the county jail, that he complete drug and get into and complete drug and alcohol treatment. And Your Honor, he would need a 12-month extension. I believe at his last show cause in June, he was extended 12 months on June 21st, but to avoid him not being able to complete treatment within the allotted time, state would ask for a 12-month extension from today's date. And the court will need to address court-appointed attorney's fees as Mr. Watts has been reappointed.
Mr. Watts, your recommendations regarding an appropriate disposition.
Well, Your Honor, I will note, as I mentioned earlier, Mr. Dillon didn't hesitate to acknowledge where he'd failed here. He didn't try to deny any urine samples. There are a couple of things that has changed. A, he has work. In fact, I understand he has work tomorrow at, you said $18 an hour? Is that correct?
It's $12 an hour.
$12 an hour. Okay. So he has work tomorrow and desperately wants to go back to that. There's one other thing that's changed. Mr. Dillon tells me he now has a child born sometime last month. I don't know the exact date, born in February. And perhaps most important, first thing I asked him when we came on is, if you tested today, would he be clean? And the answer was yes. He was in jail from February 14, according to Mr. Dillon, arrested on the 14th, out March 3rd. So he's had about 17 days in custody. Since March 3rd, we're now at the 14th, not quite 2 weeks. He tells me he is clean. Again, I've not tested him. I have no way to do that. But if that's the case, we're making progress. He has work. He has, at this point, back into treatment program, and he has a child now to take care of. And he spent 17 days in county jail. So, Judge, what I'd like to say is that the time that he served should take care of that sanction and should get his attention. 17 days rather than a 2 or 3 day dip. If the court believes it is necessary to impose further sanction, I would encourage the court to schedule that time so he can continue to attend his job and continue to work.
How much are your fees in the representation of the client on this round of proceedings?
Judge, we're billed for $880 at a show cause.
All right. Mr. Dillon, I'll address you personally and I'll ask you, do you have any statements that you wish to make in mitigation of punishment here? Or anything further that you would like to present to the court?
No, Your Honor.
You just had a child born to this world?
Yes, he was born February 25th. And
His
his
name?
mom's in the hospital right now.
Okay.
So with
What's the child's
schizophrenic.
name?
Leonidas.
And I trust he has a last name?
Yeah.
Dylan?
Oh, last name? Yeah, Dylan. Yeah.
Oh, okay. It
I'm
wasn't a good question.
Sorry.
All right. And you're saying the mother is in the hospital right now? So who's providing care as we speak?
Me and her grandpa. Or his grandpa, excuse me. He's a little guy. He was born a month early.
And he's off to a rough start, obviously.
Yeah, well, his mom, she's not the best, so.
Well, Mr. Dillon, why are you taking chances when you've got a child to take care of? I don't understand why you're just not doing what you're supposed to be doing. You can stay in the community. You can be on probation. You can take care of your child. If you do what you're supposed to do, you don't have to serve time in jail. But unfortunately, your track record is you just can't consistently do what you're supposed to do.
Well, me serving that time has really woke me up. I'm going to be honest with you. That and not being there for him when he was born, that really hurt me. I understand that I have messed up and I am making an effort to make it right. I promise you that. And all my fines are paid off. Well, of course, I'm going to have more, but from previous, everything's been paid off.
You like marijuana?
No. I did, but not now. I've learned my lesson. I do not want to go to jail. I've learned my lesson. Trust me. I like I told him I would be clean today if I do a UA. I have not used. Like I said, I'm back in treatment. I'm making an effort for my son and for me.
You have a lot to be on probation for, Mr. Dillon. You're just about ready to blow it.
I know that, Your Honor.
All right, first of all, the court's going to take into account that Mr. Dillon has served 17 days in jail in regards to this warrant to show cause. The court, while believing at least on its face that the state's recommendation is sound, the court's not going to order the 30 days of sanction time, which was suggested in this case, rather recognizing that Mr. Dillon has taken some corrective steps regarding the allegations which are currently before the court. The court at this time will take into account the 17 days previously served, but there must be a prospective sanction here. Mr. Dillon, in some ways, I'd really like to make this hurt so that you sit in jail and you wonder what in life you're giving up. And I'm not necessarily wanting to interfere with a job that you've just started, but I'm going to order you into custody immediately to serve an additional 48 hours in jail, starting immediately. While a court could make that a much, much longer sanction, and perhaps under these circumstances it should, again, taking into account that it's already cost you 17 days of your life on this round, and the deprivation from your young child who probably needs you right now. But apparently, at least at one point here, relatively recently, marijuana was more important to you than any of that.
Yeah,
You need to break yourself from that, Mr. Dillon.
I have, Your Honor.
Your son's counting on you to do that.
I have. I promise you that.
All right. Mr. Ketley, at the first in-person meeting after he is reinstated onto your probation, in other words, as soon as he gets out of this 48-hour sanction period, he's reinstated on community corrections and extended through December 31 of 2025. He needs to satisfy any condition that hasn't been previously satisfied, including a proper re-engagement and completion of a substance abuse treatment program and any aftercare recommendations. But at that very first meeting, Mr. Ketley, I'm going to order that he be UA'd. I know you're probably just as interested as the court is. Is he telling the court the truth that he's going to be clean on a UA right now? I wonder. I hope so. Dylan, I have every reason to believe you, but we're going to check that out.
I just did a UA for my treatment, so.
Well, I'm going to want Mr. Ketley to do another one.
Okay.
You and marijuana are permanently divorced, Mr. Dillon.
I know that, Your Honor. Trust me.
Okay. All right, so I've extended probation through the end of this year. Ms. Norris, I need to address further assessments in the case. Because you messed up again, Mr. Dillon, I really should hit you with some additional bids costs in this case. I'd rather see you spend this money on your son and his care.
I appreciate that, Your Honor.
He needs to be the recipient of the funds that you earn to some extent. So I'm not going to assess any additional bids amounts at this point. I'm ordering Mr. Dillon into custody to serve 48 hours sanction time effective immediately. With that re-pronouncement, Ms. Norris, is there anything else we need to address?
Your Honor, what was the day in December of 2025 for completion?
I am extending him through December 31 of 2025.
31. Okay. Thank you, Your Honor. Nothing further, I don't think.
All right. Mr. Ketley, do you have any questions or any further clarification needed?
No, just Dylan, I need to call me first thing Monday morning and let me know when you can come in.
Yes, sir.
And when you get to jail, call your job too.
Okay.
All right, Mr. Watts, anything further that the court needs to address currently?
No, sir, thank you.
Very well. Then the Jordan Dillon matter will currently be in recess. It is case number 2023 CR 82. Amber Norris appears for the state of Kansas. James Watts is defense counsel. Mr. Dillon appears at a court security Zoom location at the Butler County Courthouse. Court notes that this defendant was originally sentenced back on June 23rd of 2023. At that time, on a flee elude level 9 felony charge, he received a 6-month DOC sentence, 12 months PRS with a 12-month reporting probation. Mr. Dillon has been back before this court on previous occasions. In 2024, and then again earlier in 2025, both times receiving essentially dip jail sanctions for noncompliance with the terms and conditions of his probation. Matter comes before the court at this time for the third time on review of his original sentence on a warrant to show cause filed by Mr. Ketley. The defendant is alleged that in April and May of 2025, he submitted urine samples positive for THC. Further, unsuccessful discharge from substance abuse treatment at higher ground due to lack of attendance is alleged back in May of 2025. Mr. Watts, what are your client's intentions regarding these allegations?
Your Honor, I spoke with my client regarding the allegations. He's first alleged that he submitted urine samples positive for THC in April and May of this year. He would stipulate that in fact that is the case. He further stipulate that he was unsuccessfully discharged from the substance abuse treatment program at higher ground in May of this year, would waive hearing on those matters. He would tell the court, it's my understanding, my client reports that he is currently have an evaluation set up for Tuesday to re-enter that higher ground program. But he would stipulate to the violations as alleged and waive hearing in the matter.
Very well. Mr. Dillon, your attorney has announced that you would now waive any due process hearing that you'd be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. You would have the right to challenge the state's evidence, present your own evidence, have the assistance of counsel, confront the state's witnesses unless good cause was shown. And I need to point out to you that among other lesser remedies, such as the ones the court has used in the past, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, Your Honor.
And do you waive a hearing in this case and stipulate and agree that you committed the violations as alleged in the warrant to show cause, which are submitting urine samples positive for THC and unsuccessful discharge from substance abuse treatment?
Yes, Your Honor.
Very well. Court finds that the defendant is knowingly and voluntarily waived a hearing in this case, stipulate and agrees that he committed the violations as alleged in the most recent warrant to show cause. These are substantial and material violations of the terms and conditions of the defendant's probation with community corrections. We'll now turn to disposition. The court will take recommendations in this case. Ms. Norris, on behalf of your office, what recommendations are made?
Thank you, Your Honor. This is defendant's third warrant to show cause in this case. He's previously been before the court. He was before the court in March, where the court gave him 2 days in jail and an extension. Before that, he had 3 days on a probation violation back in June of 24. And then he's also had 2 and 3 days from his ISO for voluntary sanctions with his community corrections officer. Your Honor, his problems seem to be the same. He's having dirty UAs and he's not engaging in and or completing substance abuse treatment. Those are consistent issues that the defendant has been having throughout his probation. I think, basically in all 3 warrants to show cause, these are the same issues, still using, still having dirty UAs, and still not going to and or completing treatment. Same with his previous sanctions that he did voluntarily with Mr. Ketley. Those have to do with his substance abuse treatment, either not re-engaging or being unsuccessfully discharged from the program. Your Honor, it appears that he's just not getting it at this juncture. We are basically about 2 years in on probation, and defendant still is not quit using, and has not completed treatment as the court ordered as a condition of the probation, basically from the very beginning. Your Honor, we're just over 2 years from the date of original sentencing, which was June 23rd of 2023. The defendant was ordered to 6 months DOC. And Your Honor, at this juncture, based on the same behaviors being repeated over and over again since going on probation in June of 2023, state would request that the court revoke the defendant's probation and that he be remanded to serve the balance of his underlying sentence. He has 27 days of jail time credit from basically all the sanctions that he has served, whether they be the voluntary ones with Mr. Catley or the ones that the court has ordered as sanctions for his previous probation violations. We would ask the court address additional court-appointed attorney's fees and the bids application fee. And I do believe that any and all fees still due and owing would need to be forwarded to collections.
Very well, Ms. Norris. Mr. Kentley, as the ISO assigned in this case, do you have recommendations to the court independent of Ms. Norris or in addition to Ms. Norris?
I don't, Your Honor.
All right. Mr. Watts, I'll turn to you. As defense counsel, what recommendation do you make regarding an appropriate disposition here?
Well, Judge, I'd love to tell you that I have something different, specifically different from the state in terms of why we're here. Mr. Dillon seems to maybe making the same mistakes over and over again. And at this point, he has gotten a couple of relatively brief sanctions in the county jail. I would argue, Judge, it's time for a county jail sanction, but a significantly more severe one, starting with a minimum of 30 days and perhaps up to 60 days in the county jail. My clients tell me county jail time is much more significant than Department of Corrections time. They'd rather serve it DOC or serve it in DOC than county jail. I would hate to, however, to simply throw our options away with this young man. He's still relatively young. So, Judge, we'd recommend a 30 to 60-day sanction in the county jail.
Understand your recommendation, Mr. Watts. Court at this time will address Jordan, Jeffrey, Dean, Dillon at this time, and I'll ask the defendant personally. Mr. Dillon, do you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present here?
I know I've messed up and whatnot, but I have my son that was just born on the 25th, and I've been making sure ever since I got out last to stay out the way and not do anything. I know it's too late, but I'm sorry about that, and I accept whatever you all decide.
Mr. Dillon, what I don't understand is here you are on felony probation and you continue to mess around with an illegal substance called marijuana. Why take the risk, especially when you are a recent father? Why would you mess around with a street drug like that? I just don't understand.
I honestly, I don't know. I was just raised around it, but I ever since I got out last, I have not been using. I've been, just staying clean and whatnot. I've been trying to do right.
Well, you just got out last, apparently, about June 16th. At least that's when you made your appearance before the judge on this warrant. And you apparently bonded out soon thereafter. I note that the bond that I see in the file from earlier this year was with second chance bail bonds. Of course, that was actually your third chance. Mr. Dillon, the court also notes that the crime of conviction in this case is not necessarily just a drug possession crime. It was a flee and elude law enforcement, which this court generally considers to be a very serious offense because of the potential that while you're eluding law enforcement, somebody else gets hurt that's innocent because you take elusive steps instead of submitting to law enforcement in the first place, which is not only dangerous for the officers involved, it's dangerous for you or any passengers in your car or innocent bystanders or other people on the roadway. So it's a serious crime to the point where the legislature has made it a person felony. So they consider it obviously a very serious crime. Now, you received a relatively light sentence to start with. It was this court's goal, Mr. Dillon, that you successfully complete probation. And I have no doubt that it was Mr. Ketley's goal that over the past couple of years to try to turn you into a successful completion of community corrections assignment. But you refused to let yourself be successful. There were a couple of things that you were required to do. Stay away from drugs, which, at least to the court, seems relatively straightforward and easy to follow. And number two, because you have some underlying issues regarding decision-making, to get through and successfully complete a substance abuse treatment program. You didn't do that either. And that was, to a certain extent, a focal point of your probation. So if you're not going to stop using drugs and you're not going to go to treatment to try to change your behaviors, the only thing left for this court to do is to enter an order, and the court does enter an order, a finding that Mr. Dillon has not successfully completed probation, that his probation has failed, that this is essentially the fourth time Mr. Dillon's been before the court to address this case, the original probation. Twice before we were here on revocation. Apparently, Mr. Dillon, nothing I said or nothing this court did on those prior revocations made one bit of difference to you. And I have no reason to believe that if I were to enter probation orders again today, even after a sanction period is served, that that's going to have any impression on you either, quite frankly. You just don't want to make all the changes necessary to be successful on probation. And what you've done over the last few weeks does not convince this court that you would be a candidate for long-term success. So regrettably, this court will enter an order at this time outright revoking the probation of Jordan Jeffrey Dean Dillon, ordering him to serve the remaining balance of his prison sentence in Department of Corrections custody. Because of this order, the court will waive any additional business assessments. Any unpaid amounts in this case will be referred to collections if there are any. I will announce in this case that the original sentence, of course, was 6 months. And I'm going to presuppose that the post-release supervision period was ordered at 12 months.
I think that's correct, Your Honor.
It is.
Yes, it is.
Mr. Dillon, a couple of recommendations from the court while you're in Department of Corrections custody, and you won't be there very long. Earn every good time credit day you can so that you can get out as soon as possible. And while you're earning those good time credits, if they have any type of rehabilitative program that you might benefit from in Department of Corrections custody, that you take advantage of that program so that you can be 100% successful when you get out in just a few months. The sentencing journal entry from today needs to reflect the accrued jail time credit. Ms. Norris, I have little doubt that your computation that you gave the court today is a correct one. Apparently 27 prior days. And I'll just make the observation that that obviously constitutes a great number of different jail stints, Mr. Dillon. I don't know how 27 days got accrued 1, 2, and 3 days at a time, but obviously you've had a number of jail stints and they just haven't worked to correct your behavior. And I think it reinforces and backs the court decision that jail sanctions are not going to be effective in helping you complete probation or the sentence in this case. So I'm going to order Mr. Dillon into immediate custody of the representatives of the Butler County Sheriff's Office until his custody can be transferred to the Department of Corrections to serve the remaining balance of the 6-month prison sentence originally ordered and reaffirmed by the court today. Anything else we need to address here, Ms. Norris?
No, Your Honor, thank you.
Mr. Watts?
No, sir.
Very well. If there's nothing further, the Dillon matter is in recess.